You're in your hands.
Oh, thank you. And I'll introduce my colleagues when I've finished. I have about 10 minutes worth to say, and that gives you 10 minutes. Thank you. As you'll be aware from my written submission, I think one-stop shop processes make sense. As for fast-tracking processes, that too may be unobjectionable, although I would note that no process should be lengthier than it needs to be. I think we should have the cost and time of any processes under permanent review. And there are horror stories out there. The bill's most objectionable features lie elsewhere, and I want to underline two of them today. The most important is the systematic attempt that's been made to exclude consideration of the risk of environmental harm at every turn. Just let me remind you of some of the main ones. Firstly, the purpose of the bill is limited exclusively to the delivery of infrastructure and development projects with benefits, national and regional. Secondly, the Minister for the Environment is excluded from the list of ministers responsible for referring proposals to panels and ultimately considering their recommendations. She isn't even among those from whom expert panels must invite comments. Thirdly, in determining whether projects should be referred to panels, there's no requirement for ministers to consider the environmental harm that may be associated with those projects. And of course, that's for the ones which are referred. For the projects that are going to be listed, the criteria are completely unknown. Fourth, ministers are explicitly authorised to approve projects that would otherwise be prohibited or would have been previously declined after investigation on environmental grounds. And finally, when making their recommendations to ministers, expert panels are required to give priority to the purpose of the bill, which, as I've noted, is silent on the question of the environment. Now, the bill's authors seem to have concluded that excessive concern for the environment is the problem. I don't think any evidence has been provided to support that. And I just remind you that fewer than 1% of all consent applications are declined. And even for the more complex notified ones, the decline rate is 7%. I would strongly recommend that the committee requests the attendance of the Infrastructure Commission. You need to get them here, and you should ask the Commission if legislation that minimises regard for environmental impacts is what they recommend to expedite progress. I think you'll learn quite a bit from them. I have, talking to them, about the ways processes can be improved, how a quantum leap is needed in our ability to quickly and easily access environmental information. This committee will have heard me say something about environmental information before. If you've got to gather it for the first time on a bespoke basis, it's going to take ages. Now, projects approved under this bill will likely be large and complex, causing long-term environmental effects and, in some cases, permanent harm to already threatened plants and animals, to water quality, and exposing people to hazards. Now, Judge Laurie Newhook, speaking recently at an environmental policy and law reform conference, shared some of his first-hand experiences chairing fast-track panels and also presiding at Environment Court hearings. I just want to share one of them with you because it really is, it's very significant. He referred to the Air case, which concerned an application for a very large above-ground water storage dam in North Canterbury. Now, there are about 200 homes located downstream of that dam. Under this bill, those homeowners would have had no ability to participate in the process, despite being in the flow path of any dam breach. Now, as it happens, the Kaikoura earthquake conveniently occurred during an adjournment in the hearings, and that threw into sharp relief the risks at stake, leading the parties and experts to come up with consent conditions that needed to address highly complex geotechnical, seismic and structural questions. They had to provide for monitoring and failure detection systems, emergency action and evacuation plans, and public liability insurance. Now, I would put it to you that it's just about impossible that this could have been resolved in 50 working days. They had to extensively test expert evidence in conference with some of Australasia's leading engineers and scientists. And let me mention another example, which is within my own knowledge, because it's only just come really to my attention in the last few months. I was asked to take a look at flood modelling, the flood modelling tools being used in Upper Hutt at Pinehaven. And I've concluded, with the assistance of people who know more than me, that it is out of date and should no longer be relied on. Now, if a housing development, and we've written to the councils and told them this, but if a housing development were to be applied for under this bill, it could be approved without waiting to update the modelling, thereby placing existing houses downstream at increased flood risk. If all you have to focus on are the benefits of development and the process is all about speed, risks are going to be missed and there are going to be disasters. Now, at-risk homeowners can at least go to the media even if they're locked out of the hearing process. But wildlife can't do that. And naturally, my principal concern is with the protection of what's left of our environment. And I just want to stress to you that this is a bit different from the frictions that arise between property owners. Things like noise, odour, visual effects can be very contentious and they can sometimes cause significant delay. And yes, there are NIMBYs out there who use processes to slow things down. They're very important to the people that are affected, but they relate to private interests. The environment I'm concerned about embraces resources that are publicly owned or affect the public at large. And that brings me to my second point. The resources I'm talking about are not private property to be exchanged, improved, compromised for private benefit. They are public property for which Parliament is ultimately responsible, and their use should offer public benefits. Now, previous parliaments have decided that the best way to allocate access to public lands and marine space, to water, to minerals, is to have arm's length processes set out in laws that spell out the factors independent decision makers should have regard to. And we live with the decision. This bill not only dramatically shrinks consideration of the environmental impacts of developments, it hands decisions on resource allocation to ministers without a requirement for a transparent evaluation of costs and benefits. Now, the committee needs to consider whether it's prepared to recommend that Parliament should hand the power to allocate public resources directly to members of the executive, and to do so having eliminated the public's right to have a say about resources they own. I mean, in this sense, the bill raises issues that are constitutional in nature. And I invite you, at your leisure, if you haven't already, to take a careful look at Annex 1 of my written submission, which compares all the previous attempts as a table to fast-track legislation. And I must underline to you, this bill is not the same as the COVID-19 bill. It is far, far more restrictive, but it's been quoted as the model for this. Now, my written submission doesn't address in detail the way in which the bill truncates statutes such as the Conservation Act or the Wildlife Act. There's a great deal of detail in the schedules to the bill that needs to be very closely examined, and I encourage you to examine forest and birds analysis forensically and take their recommendations seriously. They've got very good lawyers. I think they know what they're talking about. So those are the two principal concerns I've outlined. They lead me to recommend that the following amendments at a minimum are needed if the environment is even going to make it onto the radar screen. And I'm going to put these in order of importance, taking my inspiration from the bill, which has an order of importance, which means everything's subordinate to development. So I'm going to have my own order of importance for amendments. Firstly, this is the most important. Make it clear that the quality of the environment is an important boundary condition, both for entry into the process and any recommendations to proceed with projects. And that needs to be reflected somehow in the purpose clause of the bill. Second most important one, provide a role for the Minister for the Environment, both in respect of entry into the fast track, the right to be invited to comment by expert panels, and as a final decision maker. Thirdly, limit eligibility to projects that are likely to deliver high levels of public benefit, as distinct from private benefit. Exclude those that have previously been declined. They shouldn't even be on the table. And devise a means to allow public input to panels by organisations representing the public interest, which the COVID bill did. And fourth, and you may be surprised I put it the least, but it's still very important, having done those things, leave the final decision to approve projects with the expert panel that assessed them. Now look, these recommendations could improve the bill. It is evidently not a bill I would have written. The sooner we can get down to the announced review of the resource management system, the better. Law in the space cuts across every property right in the land. And I was saying this, and he's now sitting here to the former minister. Law in the space cuts across every property right in the land. It cuts across the interest of Maori, and it cuts across resources that are commonly owned by all New Zealanders. So we need a durable statutory solution to managing it all that enjoys a high level of public confidence and provides, and this is just as important, a settled foundation for businesses and investors. They need a solid foundation. This is bedrock law that shouldn't be subject to the politics of the moment. Now, that's my bit, Mr. Chairman, and I'd just like to introduce my colleagues because they can help me with questions. Matt Patterson, here, an engineer. This is a person who's worked for the Property Council of New Zealand. Rebecca Thornley here, is a lawyer. She's my general counsel. She's worked for Crown Law. She's worked at the heart of the public legal system. And Jeff Simmons here is an economist who's worked for the Treasury and the Productivity Commission. I just say that because I've been very fortunate to have people help me who actually have some real depth and track record in the legislative and economic process. So I'll turn to them as much as I'll rely on my own skills, Mr. Chairman. Thank you.
Thank you very much, Commissioner. Now, we have limited time, so several members have indicated they wish to ask questions. Rachel, and then Glenn, and then with leave of the meeting, David Parker.
Thank you. Thank you, Mr. Chair. I'll be very quick. Just on your fourth point around excluding those projects that have been declined, do you also include those that have been declined by the courts as well as through previous fast track processes?
Yeah, they should. Yes,
just to clarify.
The point is that you've had, you've spent some time on it and you've said no. So why would you reopen it?
Yeah, no, thank you. Just taking that clarification. Thank you.
Glenn.
May I please cede my question to Honourable David Parker?
Okay. Sure.
Thank you. You're a national MP for 20 years. You're head of the OECD environmental section. You have been appointed by Parliament as the advisor on environmental matters for some years and have confidence of members across the House. We all want efficient processes. I've got a question for you, which relates to your final point. Are you concerned that consents that are granted under this bill when environmental concerns might be overridden and public input severely constrained will have a taint because ministers have controlled the outcome that means those consents lack legitimacy, might not endure, and therefore will put at risk investment certainty?
Yes, I do. Yes, I do. And it's not just the fact that the ministerial decision-making, it's the whole process, it's the speed, it's the truncation of what's being considered. The whole package really isn't credible in terms of a process which everyone can see is transparent. Look, you don't win every decision on these things. People aren't always going to be successful, and environmental groups aren't always going to stop things. You have to live with the consequences. But I think from an investment point of view, in terms of our reputation as a country, just in the same way that we have an excellent commercial code and criminal system, when it comes to environmental law, it has to be similarly squeaky clean. It has to be something which people can feel confident that if they don't succeed, they didn't succeed in a process that was fair.
Lan.
Thank you for your submission and thank you for your work in this area. My question was picking up on you saying we need a durable environmental management system. And a number of submitters have described this as really a two-tier system where there's one rule for the majority, where they have to follow the rules and everything. And then there's another rule for, I think you called it the big end of town. Do you think there is a place for such a two-tier system and an effective environmental management system, or is this just barking up the wrong tree?
Look, I don't think you want a two-tier system where the big end of town can get there and the rest of us can't. I mean, that's one of the things that's unfair. If you go and talk to people, just the general public, about the RMA and processes, and I do a lot, there's a hell of a lot of frustration on the part of small people. And it's not the act, it's the processes, it's the way that things work, and you've got to keep working at those. So in that sense, no, we don't need two-tier. Is there a case for some special process for certain things? Yes, it'd be really a bit remarkable if when David Parker was proposing fast track, I was sceptical, I'll be honest with you, surely we should have a system. But if you look at, sure, you'd have a system which can cope with anything. But the reality is, along the way, we've determined that some things are so complex, they really need to be dealt with in a particular way. And particularly where you are running across multiple processes, bringing that all together, I think it makes sense. I wouldn't call that two-tier, but I think that the portal, the gateway to that, has to be very, very carefully defined. Again, that should be something which people are all in agreement that certain types of things can go there. The idea that ministers sit and choose some things and then make the final decision, that is a two-tier system.
Thank you.
And I think that our submission argues that access to that portal should be about public benefits, because this is about public resources that we're talking about, whereas a lot of the access for this bill seems to be about private benefits that won't accrue to the public at large.
Thank you.
Margaret.
Thank you, Mr. Chair. Thank you, Commissioner. For the benefit of the public, I never assume that the broader public are really clear about the different roles. And I know there is a lot of public interest. Can I ask you to spend a wee moment just speaking about the lens of your role and where you're coming from in terms of where your submission is focused, and the lens of the importance and the priority of what your role brings to this submission?
Sure, thanks. Very quickly, in case there's other questions.
Sure.
Look, I'm not a policy maker, and I'm not here to argue for this policy or that policy or this bill or that bill. I'm Parliament's servant. I'm here to support Parliament in its work. If Parliament comes up with a bill like this, my job is to say, right, is that going to be good for the environment? Is it going to be good for the environmental management system? So that you get objective advice, which is not coming from any particular political corner, to say, okay, here's a view on the environment. There will be other views. There's always going to be an economic view and a social view, but I'm here to help you ask questions and to give you insights on what's being proposed to you. And that's why I have a very small team, just 15 odd people. But as I've said, there's a lot of experience here. And we are happy to continue to help the committee. I've given you some constructive suggestions on how you can improve the bill. That will always be the role that I play.
Thank you. Just one more. Thank you, Mr. Chair. You mentioned in your oral submission that this bill is not the same as the COVID legislation. Did you want to just give us an example or two about what some of the distinct differences are?
Well, look, given that Rebecca actually put together a table in Annex 1, I'll let her talk about that, because she's really quite expert on this.
Thank you, Rebecca.
So, thank you, Simon, and thank you, Mr. Chair, and thank you to the committee for allowing me to speak today. If I take you to the Appendix 1, which is the table, you'll see across the top there it specifies which acts it's talking about. And first and foremost, to focus on the most important distinction that can be drawn across these pieces of legislation, the COVID-19 Act specifically included reference in its very purpose that it must continue to promote sustainable management of natural and physical resources. And that's missing, that particular focus from the fast track bill. Purpose clauses are really important, as this committee will know. They not only spell out the very reason for a law being passed, but they also become a really important interpretation tool that is applied across the rest of the provisions in the Act, and is specifically of use should litigation arise. And it's certainly one of the first places the courts will turn to. Other really critical areas in the consultation or ability to participate in the process. You'll see that on page 20 of our submission, it's the third page of the table. COVID-19 Act specifically listed organisations that represent various public interest that must be consulted throughout the process. That list is missing from the fast track approvals bill. It is also doesn't include anything that was included in the Natural and Built Environment Act, which spoke to the ability for comment to be sought from other members or organisations who may represent a public interest. So that has been removed from the fast track bill.
And I can't resist adding that the National Development Act, the much maligned National Development Act, provided for that. This goes further than any fast track legislation that's ever been proposed in New Zealand, excuse me.
Thank you.
Okay, and that seems like an appropriate time. We've used our time.
Very good.
Thank you very much, Commissioner, to you and members of your team. And as always, a useful and valuable submission.
Thank you very much.
Thank you.
Thank you.